their amended petition, the Attorney General has a table of what he says are all the numbers of cases filed by the Circuit Attorney's Office, issued cases for the past 10 years or so. And if you add up all of the ones from 2017 through 2022, so that would be during Ms. Gardner's full tenure so far, that's about 19,300 cases. In their petition, in their amended petition, they identify only 40 cases out of 19,300 where they even allege anything. And in all of those, they don't allege intentional failures by Ms. Gardner. They start in count 1 with a complaint about dismissals. But all they have are 4 cases where someone else from Ms. Gardner's office made a mistake and the case was dismissed for some reason. Again, and before I go on with that, I want to make clear that Ms. Gardner does not accept any of these allegations. I think it's pretty clear from our lengthy answer that we dispute all of these allegations. We are not, Ms. Gardner is not throwing anyone under the bus, what Mr. Bailey calls in his opposition a pass-the-buck defense. That's not the defense. The issue is whether these allegations taken as true fit the statute, and the answer is that they don't. So they start by talking about dismissals, but no intentional conduct by Ms. Gardner. It's not like alleged, as was alleged in the Moody case in the 1950s, that she intentionally engineered the dismissals of these cases. There's no allegation of that. They then talk about nolle prosequis in the second part of count 1. They point to 4 examples where there was a nolle prosequi issued. Well, the fact that a prosecutor issues a nolle prosequi, and again, all of those weren't alleged to be Ms. Gardner, they're alleged to be someone else. It's not that she's alleged to have done this intentionally.
Why isn't it a fair inference from what's been alleged that that this is intentional conduct, particularly when you take all of the contents of the whole entire petition together?
Because no actual, no conduct by Ms. Gardner is alleged to be intentional. It's not like any of the prior prosecutor cases. The nolle prosequis, for instance, are much more like the Moody case, where the Supreme Court ultimately said that even an unwise or foolish nolle prosequi doesn't rise to the level of this kind of intentional misconduct. It has to be the intentional failure of a known duty. So unless they have some fact that they can allege, which they don't, that Ms. Gardner engineered this for some reason, that doesn't meet that standard. That's not that high burden.